Hello everyone, welcome to today's DNS session. We are going to take up articles from today's newspaper, 10th of December 2022. We shall take up articles which are important for civil service examination and we shall discuss them as per the demand of the exam. Let's begin. There is an article on page number 10. BJP member moves private bill on uniform civil code in the Rajya Sabha. There are two areas of study from the perspective of civil service exam here. One is Uniform Civil Code and the other is Private Bill. Uniform Civil Code has been in news for quite some time now. UPSC has asked a question on Uniform Civil Code in the mains examination of 2015. Discuss the possible factors that inhibit India from enacting for its citizen a uniform civil code as provided for in the directive principles of the state policy. This topic was so very important and widely discussed back then that Law Commission also took up the issue, and in the report that it submitted in 2018, the last Law Commission, 21st Law Commission, it said that Uniform Civil Code is neither necessary nor desirable at this stage. There has been various opinion for and against Uniform Civil Code, and this has been covered multiple times in the DNS previously. Now a bill has been introduced in the Rajya Sabha. If the bill gets passed in the Rajya Sabha, it will go to Lok Sabha, and then it will be the appropriate time for the discussion yet again on Uniform Civil Code. So keeping UCC for another day, today we shall discuss Private Member Bill. You understand that the prime function of Parliament is to legislate, to enact laws. And to legislate or to enact laws, there's a requirement of introduction of bills. Bills broadly in the parliamentary form of democracy are of two types: public bill and private member bill. Public bills are those which are introduced from the side of the government. Government means executive. So essentially, public bill are those which are presented by a minister. And in the Westminster form of parliamentary democracy, any member of parliament who are not ministers, they are called as private member. So a bill introduced by a private member, a non-minister member of parliament, is called as private member bill. That member of parliament can even be from the ruling party. In Rajya Sabha and in Lok Sabha and in many other states, a particular day of the week is kept aside for transaction of private members' legislative business. And in Lok Sabha and Rajya Sabha, it's the last 2.5 hours of every alternate Friday from 2:30 p.m. to 5 p.m. That last 2.5 hours of every alternate Friday is allocated for transaction of private members' legislative business. Now let's look at some of the important pointers regarding private member bill. First of all, for the introduction of such a bill in the House, there is requirement of a prior notice of 1 month. For a public bill as well, there's a requirement of a prior notice, but that time is relatively short. It's 7 days. In case of a public bill, the formulation of the bill is done in coordination with the law ministry. But in case of a private member bill, the bill is largely formulated by the member himself or herself. But after the bill is introduced and before the bill is considered in the House, the Secretariat to the House, whether of Lok Sabha or Rajya Sabha, examines the compliance of the bill with the constitutional provisions. Such examination is not required as such in case of public bill because public bill is formulated in consultation with the law ministry. So these constitutional provision compliance are already checked there itself. Till 1997, a private member was allowed to introduce 3 bills in every sitting, but there was tremendous pile-up of such bills. So the rules were changed. Presently, a private member can introduce maximum of 3 bills in a session, not in a sitting, but in a session. You must also take a note of the fact that when a member retires from Rajya Sabha, the bill that he or she has introduced as private member bill lapses. Because that particular member is the caretaker of the bill. Because it has not been introduced from the side of the government. It's not a public bill. So if the member retires, the bill will lapse. Private member bill, just like the public bill, can also amend the constitution. And especially in such cases where a private member bill requires certain provision of the constitution to be changed. Committee on Private Member Bills and Resolutions It's a committee of Lok Sabha. This particular committee, called as Committee on Private Members' Bills and Resolutions, examines the bill. And only those bills which get examined by this committee gets included in the list of business for the introduction in the House. You must also know that the Committee on Private Members' Bill and Resolution, it has not more than 15 members from Lok Sabha. They are nominated by the Speaker. The term of the members is 1 year, and Deputy Speaker of Lok Sabha is always the chairman of this committee. Very important information for your prelims examination. You must also tell me in the comment section which are other committees that exclusively have members from Lok Sabha. You would also know that when the bill is introduced in the parliament, sometimes it requires prior recommendation from the president. In case of a public bill, that recommendation will be taken by the cabinet. But in case of private member bill, there might be certain provision in the bill which requires prior recommendations. It could require prior recommendation under Article 3, under Article 274(1), or under Article 117(3). In case the private member bill is having provisions that would require a prior recommendation by the president under these articles, the concerned member presenting the bill will have to apply to the president through concerned minister, depending upon the provisions of the bill as to under which ministry it will come. Through that concerned minister, such a recommendation from the president has to be taken in advance. You would know that permission of the president will be required before presenting the bill under Article 3. If the bill seeks to change the name or the boundaries of the state or to form a new state by separation of territory from any other state. Article 274(1) says that prior permission of president is required in case of bills that affects taxations in which states are interested. And Article 117(3), a bill which, if enacted and brought into operation, would involve expenditure from the Consolidated Fund of India, shall not be passed by either House of the Parliament unless President has recommended to the House the consideration of the bill. Now you know that the President can withhold the recommendation, and if the presidential recommendation is withheld, the bill cannot be introduced. If the order of the president is not communicated, that is considered as pocket veto. And that has been the case in several private member bills. For example, State of Telangana Bill 2010, State of Delhi Bill 2006, State of Vidarbha Bill 2000, State of Gorkha Land Bill 2000. They were all withheld by the president. You may be surprised to know that till date, there has been only 14 private member bills that were actually enacted by the parliament. And the last time a private member bill was passed by both houses was in 1970. It was Supreme Court Enlargement of Criminal Appellate Jurisdiction Bill 1968. In most of the cases where the provision of the bill is very good, it's socially, economically, politically very important, what the government does is it persuades the member to take back the bill so that with larger consultation, a more comprehensive bill can be brought from the side of the government in the form of public bill. You must know that at any point in time, the number of private bill introduced in the House outnumbers the number of public bills. But after introduction, the fate of the private member bill goes in limbo many a times. In 14th Lok Sabha, 300 private member bills were introduced. Barely 4% of them were discussed, and 96% lapsed even without a single debate in the House. But despite these facts, the significance of private member bill is very high. You would know that the private members, meaning the member of parliament who are not ministers, these private members comprise vast majority in membership of the parliament, especially of Raj Sabha. But they account for a very minuscule proportion of the bills which are eventually enacted into the law, because most of the bills which gets eventually enacted into the law are public bills. But still, the provision of private member bill, it strengthens the procedure in a parliamentary form of democracy. It serves a very useful purpose by drawing attention to the government to the desirability of a legislation in a particular area, in a particular field of public interest where government is not paying attention. It has been said by the previous speakers and chairman that in a sense, government gets complacent because there's a feeling that the act that has been passed by the parliament has already been done with wider consultation. So, to make any amendment in a law already passed by a public bill will take a very long time to move the government machinery to bring any effect to that amendment. So, amendment generally does not come from the side of the government naturally, organically. It has to be demanded from outside. And many a time that purpose is served by private member bill, even though they are not finally passed in the form of the act, but government persuade the members to withdraw and a public bill is brought to make the final changes, the amendments in the legislations, or even some time to come up with a new law. For example, Dr. Sita Pramanand, she introduced the Indian Suppression of Immoral Traffic and Brothels Bill back in 1953. But the bill could not be discussed in the House because presidential recommendation that was required under Article 117(3) that could not be fetched. But later, government legislation on the subject came in the form of the Suppression of Immoral Traffic in Women and Girls Act 1956. The late Prime Minister of India, Sri Atal Bihari Vajpayee, when he was member of the Raj Sabha back in 1962 to 1967, he introduced Private Members Bill, namely Companies Amendment Bill 1962. The bill seeks to ban donation by companies to political parties. The bill could not, of course, pass the number in the House, but later, government itself made certain changes in the Companies Act through Companies Amendment Act 1969 that incorporated the same provision that previously a private member bill had. To redress the problems of widows and particularly to ensure that they get property rights, Dr. Radha Kumud Mukherjee, he was a nominated member of the House. He was the nominated member of Raj Sabha. He introduced a bill to amend the Hindu law governing Hindu childless widows' right to property back in 1953. The bill was taken back on the government's assurance that government itself will bring a more comprehensive bill with wider consultation. And in 1956, the law on succession incorporating the rights of childless widows was passed by the parliament in the form of Hindu Succession Act 1956. In 1962, Sri Bhupesh Gupta, he introduced a constitution amendment bill with a view to discontinue the payment of privy purses to former rulers. You would know that the former rulers of the princely states, they were continued to be given many benefits, including financial ones in the form of privy purses, even after independence. But Sri Bhupesh Gupta, he was of the opinion that for the removal of widespread disparities in income, abolition of privy purse was a necessity. The government at that point in time, of course, did not agree with the suggestion, stating that these privileges were being given to the former rulers under some constitutional commitment. But due to the consistent effort by many members in the form of private member bills and also raising the questions outside parliament, government changed the privilege via Constitution 26th Amendment Act in 1971. This Constitutional Amendment Act abolished the payment of privy purses and the privileges to the former rulers of princely states. Similarly, there has been demand through various private member bills to lower the age of voting from 21 to 18 years. When all these recommendations were made, all these bills were either asked to be withdrawn or were defeated in the parliament, but later government itself brought an amendment act for the constitution or a public bill incorporating these provisions. The voting age was reduced from 21 to 18 by 61st Constitutional Amendment Act in 1988. There was also a demand to amend Article 74 to specifically provide that the President shall act in accordance with the advice of the Council of Ministers. And the same was done by 42nd Constitutional Amendment Act 1976. Constitution has a provision for setting up interstate council. This provision is in Article 263. One of the private member bill asked for constitution of this interstate council for better coordination between the states. When it was asked for, government of course did not agree, but later government instituted interstate council under the provision of Article 263 by a presidential order. Similarly, whistleblowers protection, prevention of cruelty to animals, prevention of hunger and malnutrition and right to food, transgender rights for instance, all these have been demanded by private member bills. All these socially, economically important issues which sometimes remains untouched by the public bills. Focus on these are brought by private member bills. And even if these demands are not met at that point in time, later government itself brings public bill incorporating the provisions of these private member bills. Government enacted Whistleblower Protection Act 2014, Prevention of Cruelty to Animals Act 1960, and National Food Security Act 2013. So if we look at the stats, there has been only 14 private member bill that has been finally enacted by the parliament. But analytically, if you look at the influence of private member bill in the overall legislative process of the parliament, that is par excellence. The success of private member bill in the field of legislation will obviously depend on the quality of legislation sponsored by the member. Because support from the law ministry is not there, the formulation has to be done by the member itself. So the members will have to take interest in the day-to-day working of the parliament. They have to pick up right issues and also should have the skill to formulate a bill in accordance with the constitutional provisions. If the private members have taken sufficiently important issues, then that will stimulate public opinion on the matter. And if sufficient support is garnered, the government will extend support to the bill. For example, in case of transgender rights bill. And even if the government does not extend support to the bill, in the course of time, since the issue is important, the government will be forced to bring a public bill on the issue. So it is understood that the procedure for private members' legislation is indeed quite effective in influencing the thinking of the masses and drawing attention of the government to issues of public importance. There is an article on page number 9, MCD poll win an entry into Gujarat Assembly, boost AAP's national dreams. This article is about the Aam Aadmi Party fulfilling the criteria to be recognized as a national party. So, from the perspective of prelims examination, we shall quickly see what are the conditions to be fulfilled in order to be recognized as a national party. The criteria are in terms of percentage of votes and also in terms of number of seats. If a party fulfills any of these three criteria, it can be recognized as a national party. See, the first criteria in terms of percentage of seats is this. If the party secures 6% of valid votes polled at any 4 or more states at a general election to the Lok Sabha or to the Legislative Assembly. And in addition to this, it wins 4 seats in the Lok Sabha from any one state or more than one state. So 6% of valid votes in the state assembly election or the general election to the Lok Sabha. And apart from the 6% votes, it must also have 4 seats in Lok Sabha. The Aam Aadmi Party has fulfilled this particular criteria. You know that they are in power in Delhi and Punjab. So obviously in these two states and UT, the 6% vote criteria is fulfilled. In Goa, they had 6.77% of votes. And recently in Gujarat Assembly election, they have secured around 12.8% of votes. So in 4 states and UTs, they fulfill this criteria of 6% of valid votes. There is criteria of having 4 seats in the Lok Sabha, which again they have. In the last Lok Sabha election, they secured 4 seats. So with this particular criteria, AAP has fulfilled the condition to become a recognized national party. But apart from this first criteria, which is in terms of percentage of votes, there's another criteria in terms of number of seats. If a party wins 2% of seats in the Lok Sabha at the general election, and these candidates are elected from 3 states, the first one involves 4 states. In this criteria, if the party wins 2% of seats in the Lok Sabha, and this 2% of seats must come from 3 or more states, then also it will be a national party. Or the third criteria is if it has been recognized as a state party in 4 states, then also it will be a national party. National party no way suggests that it is in power or it is in substantial number in the parliament. National party simply means that it has a wider national coverage. So from this third criteria, let's also learn what is the criteria to become the state party. To be recognized as a state party by the election commission, again there will be criteria in terms of percentage of votes and percentage of seats. If a party secures 6% of valid votes polled in the state at a general election to the Legislative Assembly of the state, and in addition it wins 2 seats in the assembly. or it secures 6% of the valid votes polled in the state at the general election to the Lok Sabha from the state, and it wins at least one seat in the Lok Sabha. So 6% of votes in the state assembly and two seats there, or 6% of votes in the general election to the Lok Sabha and one seat there in the Lok Sabha. These two are in terms of percentage of votes clubbed with the number of seats. There's a third criteria in which if a party wins 3% of seats in the legislative assembly, not in terms of percentage of votes, but in terms of percentage of seats. If 3% of seats are secured in the legislative assembly, or 3 seats, whichever is more. If the legislative assembly has less than 100 seats, then 3% would be less than 3. But in that case, that 3% won't be counted. At least 3 seats still should be secured. So 3% or 3 seats, whichever is more. So this is in terms of percentage of seats from the legislative assembly. There's also a criteria in terms of seats for the Lok Sabha. If the party wins at least one seat in the Lok Sabha for every 25 seats, suppose the state has been allocated 50 seats, then it has to win 2 seats altogether, or any fraction thereof. Maybe the state has not been allocated 25 seats, maybe it has been allocated just 11 seats. So in that case also, it has to be winning at least one seat. Then the party will be recognized as a state party. There's a fifth criteria to be recognized as a state party added in 2011. If the party secures 8% of total valid votes, regardless of number of seats that the party gets. There's a curious case of BSP in 2014. BSP secured 11% of votes in 2014 general election to the Lok Sabha, but number of seat was 0. So it may happen that despite securing substantial percentage of votes, those votes may not translate into actual number of seats. So if a party secures 8% of total valid votes, either in the assembly election or in the general election to Lok Sabha, still it will be recognized as a state party regardless of the number of seats being secured by the party. There would be, of course, certain benefits to be recognized as a national party or the state party. The foremost benefit that the party enjoys is in terms of party symbol. Every national party is allotted a symbol exclusively reserved for them to be used throughout the country. And similarly, the state parties are allotted a symbol exclusively reserved for them to be used in the entire state. But the same symbol can be used by another state party in another state. In terms of registered parties, those parties registered by Election Commission but has not been recognized as a state party or a national party, they are called as registered unrecognized parties. Those parties, they can choose from a list of free symbols given by Election Commission of India. They cannot have a symbol of their choice. You must have been reading in the newspaper regarding the spat between the two factions of Shiv Sena. And you also must have read that Election Commission of India has disallowed the previous symbol to be used by any of the faction, and each faction had to choose from a list of symbols given by Election Commission of India. So this is the thing. Shiv Sena is a regional party. They cannot have a symbol of their choice. They have to choose from the list of free symbols given by the Election Commission of India. There are other perks like time for political broadcasts on the state-owned television and radio stations, All India Radio and Doordarshan. State parties and national parties, they also get free 2 sets of electoral rolls by the Election Commission. It helps them to plan their election strategy, and these parties also gets people not registered yet into the electoral rolls. The recognized parties need only one proposer for filing the nomination. And you tell me how many proposers are required by unrecognized parties. Recognized parties are allowed to have 40 star campaigners. Unrecognized parties, they are allowed to have 20 star campaigners. And in case of recognized parties, the expenses of star campaigners is not to be accounted for in the election expense of a particular candidate for whom the star campaigners are campaigning. This is a huge benefit because the expenses in rallies of star campaigners are very high. Before AAP fulfilling the criteria to become a national party, there was 8 recognized national parties. Communist Party of India, Communist Party of India Marxist, Indian National Congress, Nationalist Congress Party, NCP, National People's Party. This is the first recognized national party from Northeast. All India Trinamool Congress, Bahujan Samaj Party and Bharatiya Janata Party. There is another article in today's newspaper. Center introduces bill to modify scheduled tribe list in 4 states. The Central Tribal Minister, Mr. Arjun Munda, has introduced bills that seek to modify the scheduled tribe list in 4 states: Tamil Nadu, Karnataka, Himachal Pradesh, and Chhattisgarh. The bill seeks to bring amendment in the Constitution Scheduled Tribes Order 1950. In the course of the discussion, you will understand that scheduled tribe declaration is done by the president by the presidential order, and this is that order. But if you want to make changes in that list, that has to be done by the parliament via amendment, and that is why this bill is required. For the coming prelims examination, you should be aware of certain things. You should know that the term scheduled tribes is mentioned in the constitution, but it is not defined. Clause 25 of Article 366 refers to scheduled tribes as such tribes or tribal communities or parts or groups within such tribes or tribal communities as deemed under Article 342. And Article 342 Clause 1 reads like this: the President may, with respect to any state or union territory, and where it is the case of a state, after consultation with the governor thereof by public notification, specify the tribes or tribal communities or part or groups within tribes or tribal communities which shall, for the purpose of this constitution, be deemed to be scheduled tribes in relation to that state or union territory. So remember, scheduled tribes are declared for a particular state or union territory. Clause 2 of Article 342 says, Parliament may by law exclude or include from the list of scheduled tribes specified in a notification issued under Clause 1 any tribe or tribal community or part or group within that tribe or tribal community, but save as aforesaid a notification issued under the said clause shall not be varied by any subsequent notification. The language is very convoluted, but what it means is this. Scheduled tribes are notified by order of President, and they are notified for a particular state or union territory. In case of a state, governor's consultation has to be done. Once notification has been out, it can be modified only through Act of Parliament. The criteria generally that the executive follows for declaration of scheduled tribe has been given by Lokur Committee, which was formed in 1965. The committee specifically was formed to look into criteria for defining scheduled tribes, and the committee gave 5 criteria. Number 1, the tribe should show primitive traits in their way of life, in their habitats, in their economic activities, in their agricultural practices, etc. They must have a distinctive culture. They must have geographical isolation, shyness of contact within the community at large, and economic backwardness. Scheduled tribes have been notified in 30 states and UTs in India, and no community has been declared as scheduled tribe in the state of Haryana and Punjab and union territories of Chhattisgarh, Delhi and Puducherry. The state of Odisha has highest number of tribes declared as scheduled tribes, numbered 62. And as per the last census of 2011, Madhya Pradesh has highest population of scheduled tribes. Scheduled tribes comprise roughly 8. As per the census of 2011, scheduled tribes comprise 8.6% of India's population.
There is an additional concept of particularly vulnerable tribal groups. This is not a constitutional concept. Constitution does not mention this term, but on the recommendation of Dehbar Commission back in 1960-61, this additional category was mentioned. This additional category was created because it was felt within scheduled tribe there are certain categories who are more vulnerable. Initially they were called as primitive tribal groups, but calling them primitive is pejorative. It sounds insulting, hurting their dignity, because many of the tribal groups culturally, even on the basis of scientific knowledge, are very advanced. So later they were renamed as particularly vulnerable tribal group. You must note that scheduled tribes is a constitutional concept. They are declared by President and Parliament can amend that declaration. But particularly vulnerable tribal groups are declared by Ministry of Home Affairs. It is not a constitutional concept. Altogether, there are 75 tribal groups who have been declared as particularly vulnerable tribal group. Odisha is the state that houses highest number of particularly vulnerable tribal group, 13, followed by Andhra Pradesh, 12. In 2019, UPSC has asked this question. Consider the following statements about particularly vulnerable tribal groups. Number 1, they reside in 18 states and 1 UT. True, as we have just seen, a stagnant or declining population is one of the criteria for determining particularly vulnerable tribal group status. The statement sounds very benign, you can go for it. Actually, there are 4 criteria. One is a pre-agricultural level of technology, a stagnant or declining population, extremely low literacy, and a subsistence level of economic backwardness. Third statement was there are 95 particularly vulnerable tribal groups officially notified in the country so far. UPSC has started to give numbers incorrect, which previously it didn't do. They have started to do so from 2016. The number as we saw is 75, not 95. So third statement was incorrect. If you remove third statement, you will reach to the right option, C. The topic scheduled tribe is very important for prelims, for mains. In mains, both for GS paper 1, for GS paper 2. In GS paper 1 in 2017, UPSC asked, what are the 2 major legal initiatives by the state since independence addressing discrimination against the scheduled tribes? Previously in 2016, they asked, why are tribals in India referred to as the scheduled tribes? Indicate the major provisions enshrined in the Constitution of India for their upliftment. Provisions enshrined in the Constitution, but the question came in GS paper 1. We have seen in the beginning that President comes out with a notification listing down the scheduled tribes. Schedule actually means a list, and that list of scheduled tribes also goes into one of the schedules of the Indian Constitution, and that's why they are called as the scheduled tribes.
See, there is something called as affinity test. The administration so far has been relying on affinity test for the purpose of giving certification for scheduled caste or scheduled tribe. It is used to test or examine the anthropological and ethnological traits of a person, and hence to link a person to a particular tribe. Affinity here means association. Association with a particular tribe for which the concerned individual is seeking the certificate. And this affinity test is done on the basis of some parameters like deity, rituals that individual and the tribes follow, mode of marriage, death ceremonies, method of burial of dead bodies, and other such parameters. So the certificate issuing authority matches these traits in the individual and the anthropological and the ethnological traits of the tribe. But lately, a bench of Supreme Court has opined that there is likelihood that contact with other cultures, migration, modernization, would have erased these traditional characteristics of a tribe. Back in 2009, a full bench of Bombay High Court held that the affinity test was an integral part of the verification process for caste certification. Scrutiny committees shall easily determine the authenticity of a claim by running an affinity test on the basis of ethnicity and anthropology. But just 2 years after, Supreme Court in 2011 has given a cautionary note. It indicated that the affinity test may have run its course. And in Anand versus Committee for Scrutiny and Verification of the Tribe's Claim, reasoned that affinity test may have been a determinative factor a few decades ago, when the tribes were somewhat immune to the cultural development happening around them. But with migrations, modernizations, and contact with other communities, these communities tend to develop and adopt new traits, and which may not essentially match the traditional characteristics of the tribe. So naturally, affinity test may not be regarded as a litmus test for establishing the link of the applicant with the scheduled tribe. And hence the stand of the bench of the Supreme Court was that the affinity test may be used to corroborate the documentary evidence and should not be sole criteria to reject a claim. But what will be the criteria to accept the claim? For that, the bench of the Supreme Court has opined that the matter should go to a full bench of Supreme Court. This perhaps will be settled in due course. Now let's take up this another article from today's newspaper. Karnataka High Court shocked by the agreement for adoption of unborn child. The problem here is that adoption in India is only permitted in a formal institutional manner. Any adoption must involve CARA, the Child Adoption Resource Authority. Let's take things here one by one.
Central Adoption Resource Authority, first of all, is a statutory body. It works under the Ministry of Women and Child Development. It has been working since 1990s, but it has been given the statutory status in 2016 under the Juvenile Justice Act 2015. Government of India ratified in 2003 the Hague Convention on Inter-Country Adoption 1993. So an important body which preferentially should be statutory was required for the need of regulating this inter-country adoption. And finally, in 2016, statutory status was given to Central Adoption Resource Authority, which was already working since 1990. So regulations on adoption related matter is formulated by CARA. You must note that Central Adoption Resource Authority has allowed individuals in a live-in relation to adopt children from within India. This decision was taken in 2018. So CARA is at the helm of affairs in the matter of adoption. CARA must be involved in any adoption process that is taking within India. Supreme Court although has passed judgment of banning all the adoptions of children who have become orphaned in last 1 year. But Supreme Court obviously was informed by National Commission for Protection of Child Rights. NCPCR has a portal called as Bal Swaraj. In this Bal Swaraj portal, it has been informed to the Supreme Court that between April 1 last year and June 5 this year, 3,621 children were orphaned. Around 26,000 lost their parents and some 274 were abandoned across the country. These are just official figures. The actual number obviously will be much more. These many children have been registered at Bal Swaraj portal. In this regard, you must also be aware that National Commission for Protection of Child Rights is also a statutory body. It has been established under an Act of Parliament, and the Act is Commission for Protection of Child Rights Act 2005. It has not been formed under Juvenile Justice Act 2015. But this commission also works under the aegis of Ministry of Environment and Child Development. The purpose of National Commission for Protection of Child Rights is to ensure that all laws, policies, programs, administrative mechanisms, all of them are in consonance with the child rights perspective as enshrined in the Constitution of India and the UN Convention on the Rights of the Child. Although there are various definitions of child in India, but the definition taken up by the National Commission for Protection of Child Rights is person up to the age of 18 years. Adoption as a social, emotional or legal process has lots of benefits. If you look from the perspective of child that is getting adopted, the child who is in the critical need of resource, of having a stable life, loving family, to fulfill the emotional need of child, to fulfill the physical need of the child of having food, shelter and clothing, and also the cognitive need, the need of getting literate, the need of getting educated, the need of getting informed. These needs of child which will not otherwise get fulfilled properly if the child may be living with a relative or with foster parents. If a couple adopts a child and treats that child as their son or daughters, then the basic need of the child will be fulfilled in a better manner. If you look at it from the perspective of parents who are adopting children, they will get the opportunity to experience parenthood. Adopting a child also allows mother to continue pursuing their goals without putting their either education or career on hold, which otherwise inadvertently will be affected because of pregnancy. If you look at it from the perspective of parents who are giving their children to the adopting parents, meaning a couple is not adopting an orphan child, but a couple is adopting child from biological parents, then in that case, the biological parents will have relief from the financial and emotional stress. Maybe the pregnancy was unplanned, or maybe it is a case of a single parent, and raising a child in that case would be very, very taxing. If the adoption is done in an institutionalized manner, then it also gives a peace of mind to the giving parents, the biological parents, that their child would be raised by a pre-screened adoptive parents who will provide a safe, stable, loving and nurturing home. Not so much in India, but in foreign countries, there are proper institutional mechanisms that the biological parents can have a right to visit the child, meaning it's an open or semi-open adoption. In that case, the child gets love and affection of both the biological parents and the adopting parents, and both the parents have the opportunity of experiencing that parenthood. On the social level, if you come to think about it, raising a child is the responsibility of entire society. in different ways, in different degree. There's an old adage that it takes an entire village to raise a child or to raise a girl child. So the social collective responsibility towards the younger generation is exhibited full scale in this social process of adoption. But to fulfill this collective responsibility, there has to be value of generosity. And that value of generosity may come innately in the time of disaster. And in society like India, where collectiveness is common, couples can be more than willing to adopt a child. But you see, if love and affection are not channelized and regulated, then there could be some inadvertent adverse effect. After 2004 deadly tsunami, there were many campaigns calling for people to adopt children who were rendered orphan in several Asian countries. But it took a while for some affected countries to wake up to the reality that lax enforcement of adoption rules may have led to child trafficking in some cases. And after that, many countries strengthened their child adoption rules. Children are vulnerable to trafficking. So it's important, extremely important, that child adoption is done in a formal manner.